Shapiro.
Thank you, Your Honor. Your Honor, we are before the court this afternoon in the matter of the State of Ohio versus John Dembowski. It's case number 21-CR-638. The defendant is present in the courtroom with his attorney, Mr. John Fatika. We're here for purposes of a sentencing of the defendant having pleaded guilty to 2 counts of the indictment, those being count 2, a felony of the 4th degree forgery count, and also count 4, a felony of the 4th degree grand theft count. The parties are ready to proceed to sentencing here this afternoon.
Thank you. Mr. Fatika, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
I would. Good afternoon. I had an opportunity to review the PSR. We acknowledge that Mr. Dombrowski has had prior convictions. I'd like to highlight the fact that the closest thing he has to an act of violence is ag menacing. He has 1 prior prison and probation violation, from what I could see.
Prior prison?
In 2004.
I thought you said he has no prior prison.
No, he has 1 prior prison. But
I misunderstood you. I'm sorry.
Pardon me. And that was back in 2004. He's had some health problems. He's 41 years old. Was picked up on a traffic stop. Has no new cases. He understands that he used very poor judgment by not returning to court when he was ordered to for his sentencing in January of 2022. But we'd ask the court to consider all those factors, and if you're inclined to impose a prison sentence, to impose a concurrent sentence. Thank you.
Mr. Dembowski, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say?
Yes, Your Honor. Do you want me to stand or sit?
You do whatever you want to do.
Your Honor, I've made some very bad decisions in my life. The last year, I've been managing and operating sober houses with Tom Mulhall out in Cleveland. I have anxiety and PTSD very, very bad. I made some errors in my judgment. I didn't want to lose all the good I had done in my life, Your Honor, because of a stupid mistake. And I see that I'm going to lose it anyways. I made a mistake, Your Honor. I'm deeply sorry for my mistakes. I would just like a chance to be on probation and maybe try to make things right and pay Mr. Follett back and do what I'm supposed to do, Your Honor. And yes, I do have mental illness. I have anxiety, PTSD, and some bipolar. I probably need a lot of help with that too, Your Honor. Just honest to God, I don't know what to say, Your Honor, other than I'm sorry. I don't know.
Thank you. Anything else you want the court to consider?
No, thank you, Your Honor.
Mr. DePiro for the State of Ohio.
Thank you very much, Your Honor. Your Honor, Mr. Richard Follett is present in the courtroom here today. He owns Ramjack, and he is the victim in this case. I would ask for the opportunity to allow him to speak at this time, if it please the court.
Sure, we can hear from him at this time. Sir, you can just stand right where it is that you're seated. Spell your last name, please, for the court reporter here so we make sure we get that correct, and then take your time and say whatever you'd like me to know.
Richard Follett, F as in Frank, O-L-L-E-T-T.
Go ahead, take your time.
Well, I had a salesman that this gentleman called my company, set an appointment, and we worked up a job to do for that job. And normally we get 30% down prior to starting the job, but Mr. Dembowski said that he had an insurance check that was coming. So it was at the end of the year, and it was a basement job, so we wanted to get it done. So contrary to that, I usually took people at their word. We started the job, and 2 days into the job, we had basically half the house excavated. And that's when the excuses kept coming, and that's when I knew that I was in a bad situation. But you can't leave a house excavated open going into winter. The house would have collapsed. So we finished the job. I was $22,000 in labor and materials. I hired a block crew that I paid $5,200 for.
A what crew?
We needed part of the basement wall needed to be rebuilt. The house was caving in, and I saved it. And like I said, The price was 26 and change, $27,000 for the job.
26.8 I saw, right?
Okay, well, I had 22,000 in it. After we said it done, so really I lost almost 50. And that was going into Christmas. So I had no Christmas, my family had no Christmas, my employees had no Christmas. And then of course we don't work in the wintertime. So this all compounded itself, and then going in towards the end of 19, I had to borrow $160,000 just to get straight, because I was paying on 20%, because I was broke.
Sure.
That's all I have to say. It just, nobody's made any opportunity other than telling a bunch of judges and people that they're gonna pay me, but nobody's giving me a nickel.
Thank you, sir. Mr. DePiero for the behalf of the state.
Thank you very much, Your Honor. The court has seen a lot of different theft offenses over the years. There's a lot of different ways to commit a theft. It always involves someone getting hurt, and there's various degrees of how much that theft hurts a victim. As Your Honor heard from Mr. Follett here today, the defendant's theft offense had a significant impact on his business, on his employees, on his family. Certainly, looking at the seriousness factors, the victim suffered serious economic harm here. And the fact that it was a business and affected multiple people and his family, it extends beyond just a contract. This is work that Mr. Follett completed because he wasn't going to allow that house to fall in, and he was going to make it right because he's a man of honor. And as he said, he took this defendant at his word that he was going to pay what he owed. And that's why he went ahead and he got $22,000 of his own money into the hole based on this defendant's word. And he completed that job, and it was because the defendant kept having excuses, said, I'm going to give you a check. That is the grand theft. That conduct constitutes the grand theft. To compound it, Your Honor, it's separate conduct here. A month later, the defendant then creates a false check, a fake check, with an Ohio Savings Bank moniker and a fake routing and account number, and utters that check to Mr. Follett's agent, acting like he's satisfying that payment. It only turned into more headaches, and it was false. So he didn't need to do that forgery. It's separate. It's additional conduct, and it hurts. So the defendant, Your Honor, has an extensive criminal history, and Your Honor knows the criminal history from looking through it. And Mr. Fatika acknowledged that the defendant had been in prison in 2004. I thought that I saw on page 8 at the top that there was a second prison term. I believe what Mr. Fatika was referring to, the 2004, was from, on page 7, towards the bottom, Your Honor. It was after 2 probation violations on an F1 grand theft out of Florida in 2002 that the judge there sentenced him to 24 months in prison with 285 days credit. And then you look at the top of page 8, we're in a different state now, in Virginia. Okay, so it seems that there were 2 separate prison terms here. In 2 separate states. That's another notable thing about the defendant's criminal history. We're talking about criminal conduct in 3 states: Virginia, Florida, Ohio. And, Your Honor, there are various degrees of crimes here. And without standing here and reading every single one of them, it would take too long. I would argue and I would highlight that most of these offenses involved a victim of some kind, whether it was a theft or a breaking and entering, grand larceny, destruction of property, unauthorized use of property, passing bad checks, threatening, harassing phone calls, aggravated menacing. These are actions that the defendant takes that affects another human being in some way. Okay, and so that's important for the court to consider when the court is considering the seriousness of the defendant's conduct, the danger the defendant poses to the public. And the state would submit that the criminal history demonstrates that consecutive sentences are necessary here based on that criminal history. to protect the public from future crime of this offender. We're talking about a 20-year criminal history, Your Honor. And also here we have the second prong of the consecutive, that at least 2 of the multiple offenses were committed as part of one or more courses of conduct, and the rest of that. So, that I won't read. So, Your Honor, I think there's a very good argument here for consecutive sentences. He didn't have to do both of these. The victim is hurt severely. I would ask on Mr. Follett's behalf for an order of restitution in the amount of the check, the $26,860, because that was the amount on the service contract. Is that right, Mr. Follett? That's what the agreement was, that the defendant was supposed to pay for this work that he would have had but for the defendant's deception. The defendant does have credit for 1 day.
No, 3 days.
I'm sorry, Your Honor, 3 days.
Yesterday and today.
Right, 3 days. But I believe consecutive time is appropriate, and I think towards the higher end would be appropriate, closer to 36. Thank you, Your Honor.
Thank you. This court did review the pre-sentence report investigation that was completed at the beginning of 2022 when the sentencing was originally, actually it was completed at the end of 21 when the sentencing was originally scheduled. There's a drug and alcohol evaluation also done at that time, which I have reviewed and considered. I've considered the particular facts and circumstances of the offense involved, the nature of the offense, the history of this case. I've considered what's been said here today by Mr. Fatika, Mr. Dembowski himself, the prosecutor, the victim impact statement that was made here. All this is considered in light of the purposes and principles of felony sentencing set forth in 29-2911. For the factors in 29-2912, the court does find the victim suffered not just serious economic harm, obviously, which is obvious, but then also just emotional, psychological, in terms of the stress that he had to deal with, what he had to go through to get back on track, as we heard about. It also did have an impact on others, which makes it more serious. Nothing makes it less serious. As for recidivism factors, court finds there's a lengthy history of criminal convictions that go back, I believe, over 20 years, 2002, that these criminal convictions are of a very similar nature. A lot of theft offenses, bad check cases. There's a history here. It's not just a one-time mistake that the defendant made. This is what he does. He has failed in the past to comply with previously imposed sanctions of courts. He has been on probation before in the past. He's been given multiple opportunities on probation, violated, ultimately was sent to prison. There is a second prison term that occurred right after that as well for another theft-related charge in Virginia. He was originally sent to prison in Florida. Got out. Found his way up to Virginia. Another prison term there. No genuine remorse. Gone for 13 months. Talks about wanting to make it right. He hasn't done a thing for that. Other relevant factors indicating recidivism is more likely. The defendant did violate his bond by failing to appear for his sentencing hearing. And again, he's been on the run for more than that, 14 months. His sentencing was scheduled for January 10th. That was 14 and a half months ago. Never showed up. No factors indicate recidivism is less likely. I mean, based on the history here, this is what's going to continue. Under 29-13B1, the court finds defendant, again, has previously served a prison term. Prison is consistent with the purposes and principles of sentencing. The defendant is not amenable to any available community control sanctions. Therefore, it will be the sentence of this court Then on count 2, the charge of forgery, defendant serve a term in prison of 7 months. On count 4, grand theft, so order the court defendant serve a term in prison of 17 months. Those sentences will be served consecutive to each other for a period of 24 months in prison. Defendant has credit for 3 days he's already served. I will order restitution to the victim in the amount of $26,800. Defendant's ordered to pay all costs. Of course, also finds that consecutive service in this case is necessary to protect the public from future crime and to punish the offender, that the consecutive sentences are not disproportionate to the seriousness of his conduct, and that the danger he poses to the public, and that at least these two offenses were committed as a part of a course of conduct, and the harm caused by these two offenses was so great or unusual that no single prison term for any of the offenses committed adequately reflects the seriousness of his conduct, and his history of criminal conduct demonstrates that consecutive sentences are necessary to protect the public from future crime by the defendant. Counts 1 and 3 will be dismissed pursuant to the agreement. There is no bond to be released, so just don't even address bond in the entry. I think that covers everything. Is there anything else for the record, Mr. DePiero?
No, Your Honor, thank you.
Mr. Fatika?